Oh, there he is. All right. It's kind of like old home week with Mr. Bowen and Mr. Baseman.
Yeah, I'm afraid so.
All right, Mr. Bowen, you're up.
All right, Your Honor, most of what I'm going to say is in my brief, and I want to rely on my brief. The only one I really want to talk about is arguments 1 and 2. The arguments 1 and 2 are, I think, pretty obvious. They have a former wife who earns more money than the former husband by significant amount. She has significantly more assets in a retirement plan, like 5 times the amount. And she also has the $4,600 in 3 bank accounts. And based on my client, who only has the $2,500 in alimony and the Social Security, the court awarded under 6116 that my client owed the former wife money, which doesn't really make any sense. Now, one of the things that's been argued as in the briefs is Rosen, but Rosen is never mentioned in the order, nor is it mentioned in any of the testimony or arguments before the court. What was argued was an inequitable conduct, which is a different animal all in and of itself. In any case, though, is that the amount that's there is clear, that there is no, that my client, the former husband, did not have the ability to pay. The use of assets, the $30,000 that was owed by the former wife, is not appropriate in this particular case because there is no shown need in this matter. So that's really on the 2 issues that were there. That's all I've got for right now. I'll save the rest for rebuttal.
How about I give you like 5 minutes for rebuttal?
Okay.
Okay. I may let you expand that a little bit if Mr. Baseman gives you a lot to talk about, but don't want to give you like,
No, I won't take it either.
Hey, Mr. Baseman, you're up.
May it please the court. My name is Mark Baseman on behalf of Sherry Kletcher, now goes by Hayes. If we're only arguing the attorney's fees, I think the core of my argument, look, I'm not going to disagree that my client has superior assets, superior income. That's not the question. I think the question is, how seriously do we take Rosen and this court's more recent cases interpreting Rosen? To quickly deal with the idea that Rosen wasn't mentioned or argued, I do believe Rosen was argued in the motions that originally asked for fees, but either way, Rosen merely interprets 6116. It doesn't create cause of action.
Rosen actually wasn't mentioned in Rosen.
Well, that's a fair point. But again, it is 6116. It just tells us how to look at it. And Rosen says, yeah, we start. Rosen says, yes, you have to consider the financial resources. It says you can't do a fees award under 6116 without considering the financial resources. But then it says there are other things that must be considered. And 2 of those are the history of the case and the length of the litigation. Frankly, it doesn't even say whose fault the length is or whose fault it is through the history, but it says to consider those things. I cite this court's decision in Rogers v. Wiggins. And just to address something that shows up in the appellate brief, Mr. Bowen correctly argues that in the 4th district, the Hahamovich opinion really does seem to draw a black line that says the logic of Rosen cannot be used to make the poorer spouse responsible for the wealthier spouse's attorney's fees. I don't doubt that. I think that's a clear rule in that district. As far as I know, none of the other districts have accepted that rule. And I cite the Rogers case because our court says that. It says, although Rosen states a trial court has discretion to deny fees to a party that engages in excessive or bad faith litigation, cases have interpreted it to authorize fees against a party for such conduct. In that case, and in other cases in this district dealing with Rosen, they still say that there has to be a finding of ability to pay. But there seems to be some sort of between the lines argument going on here that when conduct is bad, or when one party causes the litigation, the key factor is more the ability to pay than need. The idea being that parties shouldn't suffer just because they have the greater ability to pay. In this particular case, there's no way to say there wasn't a literal ability to pay attorney's fees. The court found that. The court was awarding a sum of money to the former husband, and from that deducted the attorney's fees. And my position is that the case law in this district goes in that direction. That once you trigger Rosen, once there's a finding by the court that this case has gone on too long, that there's inequitable conduct, whatever you want to call it, once the court finds that, it then can award fees if it can find a literal ability to pay. The idea being that if somebody's truly destitute, it's completely inequitable to make them pay. But here there is an ability. And in my view, the trial court reviewed the file, found at the very least that this case has gone on way, way, way too long. I mean, the entire purpose of this March 10th hearing was for the trial court to put its foot down and say, this litigation has to stop. These people have not stopped in 7 or 8 years. And one of the methods the court came up with was awarding attorney's fees against the former husband. Clearly an ability to pay. Now, look, the court also found that there was a need on my client's part because she was living at a deficit. Again, relative financial circumstances, there's no question. My client is in a better financial position. But we think you take Rosen seriously when it says 6116 is supposed to be construed liberally. It's supposed to give the trial court broad discretion to do equity in these cases. Trial courts have the discretion and the obligation to control their courtroom and to control the litigation. And I think it was well within the court's discretion to decide to award fees under these circumstances where there's a clear ability to pay. Is all I would put forth unless the court has questions on this issue. And I'm obviously happy to take questions on the other issues as well.
You don't get points off for not using all your time. All right. Thank you, Mr. Baseman. Mr. Bowen.
Yes. I guess he's saying is that my client had the ability to pay because the former wife has failed over 6 years to pay $30,000 of equitable distribution that she was required to pay. But I don't think that well, first of all, a lot of Rosen cases come where the trial judge actually heard all the arguments that were being made throughout the case. In this case, this judge just got into the case and then he ruled, I've reviewed the docket, and the docket shows the case is going on too long. There is no indication that my client is the fault. Matter of fact, if the case is going on too long, it could have been set by the other side just as easily as set by mine. But the fact remains is that my client filed a motion because she did not pay karate expenses, and that karate expenses were awarded to my client. Not all of them, but awarded it. She had not paid any. So I don't know how that could have been an inequitable motion to have filed. In addition to that, we had the other case, the other order, and in that other order, it said that that it was a creeping expense. Well, creeping expense would seem to me to mean that the expense has gotten a lot more than what it was at the time of the final judgment. but there was already an order in place under a prior judge where that judge held that that the former wife was necessary. It was necessary for her to pay for this child to go to the international event, which seems to me to be res judicata. I don't see how that also is the filing of a reconsideration just to make sure that the judge understood the argument is a inequitable conduct. And if you look at it, the wife has filed a bunch of motions. She filed a motion for termination of alimony because she was going to have a reduction in pay. But it turns out that she actually had more. She made more than she ever made before. So I don't know how a judge can sit there and say, I've reviewed the document. This case is going on too long, and I'm going to go after the former husband when there is absolutely no evidence and no facts in the final judgment or in the order that indicates in any way what the former husband did that was inequitable or was not correct and would be subject to Rosen. That's fine.
Thank you both.
Thank you.
On your Zoom screen, there is a button called leave, and that's how you leave. So click that. You'll be gone.
Thank you.
Thank you
Thank
both.
you both.
Okay. The next case is Commons versus Spracklin.